So copyright is back in the news. An old case from 2017 or 2016, in fact, or the issues from 2016. Uh, Wink, which is Airtel's music streaming service, had been sued by a music label called Tips Industries. Now, the issue was that, in 2014, Tips had licensed 25,000 songs to Wink, which is similar to Spotify and Ghana and other popular streaming services. 25 a catalog of 25,000 songs for about 2 years for rupees 1.31 crores at the time. Now, when this came up for renewal after 2 years, Tips wanted more money. They wanted about 4.5 crores of rupees, which Wink didn't want to pay. So they kept negotiating for a few months, and in 2017, Wink invoked something called a compulsory license or a statutory license, after which Tips went to court to challenge it. Now, what is a compulsory license? Compulsory license is this idea that uh, the idea behind copyright is to protect the rights of the copyright holders so that they make money that creates incentive for them, uh, so that they can make more creative content. It's like they're allowed to protect what their artistic creation is in order to, and it creates an incentive structure for them. Now, this is particularly applicable to music and movies, and alongside that, there is something called a statutory license, which is that the idea behind art is that it should be communicated to the public. So someone shouldn't be in a position to aggregate all that copyright, withhold it, and use it to negotiate for a higher amount of money and effectively not provide that content to a player. So there's an older case regarding radio channels. Radio channels had sued music labels and gone all the way to the Supreme Court, arguing that they should be allowed to play music, and there's a section 31D of the Copyright Act which allows them to do so, and there should be a minimum amount or a standardized amount that they should be allowed to pay music labels. Now, music labels, especially the more powerful ones, what they tended to do at that time was that the most popular music labels, which had, let's say, thousands and thousands of really popular Hindi movie songs, would withhold that content and not provide it to one versus the other, so that they could extract more money from the ones who really desperately needed it. So, uh, compulsory licensing or statutory licensing was invoked from the Copyright Act at that point in time, saying that an artist's work cannot be prevented from exhibition. You can't withhold his music from the public, uh, uh, in ex- just because you want to try and do rent-seeking behavior. So there was a balance of public interest and artists' rights when it came to creative content that were being looked at there. So the debate then happened was that because radio services were largely struggling financially, they couldn't afford to pay more. So this typically largely went in favor of the radio services, and the music industry was not happy. But then online streaming took off, and so streaming services started arguing that this compulsory licensing regime, where there has to be a standardized payout for music, and they can just take any music and play it and pay the copyright owners a basic fee, should be applied to online streaming as well. And this case is important because this is where the test of the Section 31D of Copyright Act basically took place. The judgment has just come out, but it's been in the balance for a while, and it hinges on one really interesting aspect. Is online streaming broadcast or not? Because radio is seen as a broadcast. So what's critical here is the definition of the word broadcast in the act. Right? So broadcast under section 2DD of the Copyright Act basically says that broadcast means any communication to the public by any means of wireless diffusion, whether in any one or more forms of signs, sounds, or visual images, or by wire, including a rebroadcast. So it doesn't really differentiate between whether it's internet broadcast or radio broadcast. And that's what the test was. So the the primary sort of scope of this argument in the case that the judges looked at was is it A, being made available to the public, and B, um, is it broadcast? And by broadcast, it means that do users have a choice? So typically, when you're receiving something on broadcast, you don't really have a choice. You basically consume what is given. This is what happens in radio. But the judge was of the view that this is not broadcast simply because users have a choice regarding what they want to play and what they don't want to play. And so therefore, because it's not broadcast to the public as such, statutory licensing or compulsory licensing should not apply to Wink, is the way they looked at it. Now, what's the outcome of this case? It means that now players like Tips or music labels like Tips now have a greater negotiating ability against online streaming services. So they can charge more money if they want to, and they can withhold the music from that streaming service if they want to, which is something they can't do in case of broadcast like radio. So online streaming services are already struggling. There's a bit of a battle bit going on between multiple players like JioSaavn, Spotify, uh, YouTube Music, and of course Wink, and there's Ghana from the Times of India group. So what happens with all of this is that the negotiating ability of those players might go down, which means uh, uh, that they might have to shell out more money to music labels to play music, and you might also get a differential music experience across different players. So they will have to, if the rates go up, if the negotiation becomes harder, they will have to then choose to provide. Um, they might choose not to provide certain music because it's too expensive. And music labels now have the power to basically shut some services down by just deciding collectively to raise the fees to an exorbitant level. And I've seen this happen before. When you look at what happened with a music download service many years ago that used to be done by Flipkart, it was called Flight. Basically, year one, it went off well. Year two, because Flipkart was becoming more and more dominant, uh, the music labels collectively decided to just charge so much money that Flipkart decided it's not worth renewing that license, and it killed that service. So more power for music labels isn't necessarily a good idea, to be honest. And it does mean that some of these players are going to struggle from here on. How it plays out in the market is going to be really interesting to see. But this is one of the more important judgments to have come out, especially when it comes to compulsory licensing. And let's see if it then goes to either a bigger bench or it goes to the Supreme Court as a challenge. And it depends on whether Wink wants to pursue this case further or not. Interesting times ahead in copyright.